Christmas comes to town, it's getting cold. Baby, I just want you close. I got all this joy in my heart, and if it's getting dark, yeah, we can go inside. Baby, won't you hold me tight? I don't need any presents, 'cause I know I have you. I just need you, and I know it will be a magic holiday. Oh, make it all okay. Oh, it's a magic holiday. Ooh, the rest just fade away. It's you and me, a magic holiday. The fire's burning bright, and the snow is falling down. Honey, what you need in your eyes, that whole world disappears. 'Cause when I'm feeling down, you're there to love me right. Nothing compares to this, it's such a bliss, my only wishes. I don't need any presents, 'cause I know I have you.
Well, hello. Good morning. Good afternoon. How are we? Let me take this thing down. Prison radio. How are we, y'all? Y'all ready for today's little craziness, I guess is the word I'm looking for. So before we get started with the trial, I wanted to show you guys a clip that I found that I made for you guys. Found this just yesterday. Check this out. Something popped up on my feed this morning. It comes in from Biz Times of Milwaukee. Let me share this guy with you guys. Say hello to Frankie. He's wandering around as I try to record, as always. Miss Boese, Miss Lesli Boese of the infamous Waukesha parade attack trial, was brought up in this Biz Times thing today. It says notable litigators and trial attorneys. And it says Lesli is the deputy district attorney for Waukesha County, worked on the prosecution and trial of Daryl Brooks, who was found guilty of killing 6 people and injuring dozens of others after driving his SUV through the Waukesha Christmas parade in 2021. Boese not only carries a full caseload, but also mentors staff and interns and takes calls from law enforcement for advice. She has been involved in training law enforcement officers on legal issues for the past 23 years, and she teaches college courses on criminal evidence and constitutional law topics. She also speaks to community organizations and citizens. The impact Boese has had as a head of the Waukesha County District Attorney's drug unit is huge, said Lowell Carl, the president and chief executive officer of Loyalty Carl and Associates. She is very proud in her efforts in keeping street drugs out of Waukesha County and successfully prosecuting any who make the mistake of coming into Waukesha County to engage in drug dealing. That was what Carl said. So they just had like a little shout out for her in this Biz Times website, which I guess I don't know if they have a magazine or whatever, but I just thought that was neat, and she's one of our faves, and we all love her, especially her expressions during the trial, because she had some great facial expressions. So I wanted to share that with you guys who are as into the Waukesha community as I am. So thanks for watching, everyone. Okay, I thought that was nice that she had a little business, had a little exposure there on the corporate ladder page. Hi, everybody. How are we? Merry Christmas. Thank you. If you don't mind, hit the like button if you're enjoying my content. I would appreciate it. And let's get to it.
Facing 76 charges, including 6 counts of first-degree intentional homicide.
And just into our newsroom, we've learned additional charges have just been filed against the suspect in the Waukesha Christmas parade tragedy. These are new charges from the Milwaukee County DA. Darrell Brooks is now accused of intimidation of a witness. The court documents show that Brooks repeatedly threatened and intimidated the mother of his child.
Trial may be delayed for Darrell Brooks. He, of course, is the man accused of killing 6 people and injuring dozens more during last year's Waukesha Christmas parade.
Brooks faces life in prison.
Darrell Brooks is supposed to go on trial here in October, but the defense team says that's not enough time for them to prepare. A judge will officially decide on Monday.
The man accused of driving his SUV through the crowd, killing 6 people and injuring dozens, faced victims and their families in court for the first time.
The vehicle made contact with me and I was pounding on the hood, yelling for it to stop. But as the vehicle continued pushing through me,
Outbursts from Darrell Brooks in court today. He was asked to leave his own hearing. He's the man charged with the deadly Waukesha Christmas parade attack.
It happened just hours after he fell asleep and then lashed out at the judge and at sheriff's deputies in the courtroom.
my position changed to the side of the vehicle where I was directly outside the driver's side window, and I could see inside of the window and I could see the driver very clearly.
The court trying Darrell Brooks will meet to go over a questionnaire that will be sent to potential Waukesha County jurors to see if they can be impartial.
Brooks is expected in court today, and prosecutors say that this decision came after Brooks and his lawyers asked for a change in venue or for jurors in his trial, which Brooks's attorney said that the sheer number of people who were directly affected by the parade, along with what they call the powerful and passionate community response to the tragedy, makes it very difficult for the court to ensure a fair trial.
Multiple witnesses testified that a man they identified as Darrell Brooks came up to them after the Waukesha Christmas parade asking to use their phones to call an Uber. Those who lent their phones say he called his mother. Darrell Brooks continues to object to his name in the courtroom.
Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
A verdict in the Waukesha Christmas parade tragedy today. After weeks of reliving that horrible day in the courtroom, Darrell Brooks found guilty on all counts.
The 12 men and women found Darrell Brooks guilty of all 76 counts, including 6 counts of first-degree intentional homicide. He faces a mandatory life sentence for each homicide count. Now, the jury deliberated less than 4 hours to reach a verdict. Families impacted by the tragedy were emotional after that decision.
Here, can you just make 2 copies of that? Sure. Yes, and then 1 to each. You give 1 to each party. Thank you. Now you can,
I bumped up his audio
you can
just a little.
Sam, go ahead.
I bumped up his audio just a little bit because people on the end.
I was going to call the case.
Okay.
Do you need something to talk to him for a second?
Yes.
Go ahead. You can turn the audio off for a second.
Okay. Sir, good morning.
There she is, trying to help him again. I love it. She says, "Sir, good morning." And he doesn't appreciate it. He thinks they're all out to get him. Well, they kind of are. Let's face it.
All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good morning, Judge Lesli, Boese, and Zach Witchow appearing for the State of Wisconsin.
Good morning, sir. Please state your name for the record.
Just want to sure I have everything since they was kind of late today.
Here we go.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and do not consent to being called that name for the record.
All right, thank you. That is noted. The record will also reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing street clothes, specifically a suit and tie and a mask as well.
Thank you, Marbear.
I understand, sir. All right, I do want to put on the record I gave the parties this morning. It's an excerpt from a judicial bench book on opening statements. It's about a page and a half. I thought it would be helpful to provide to Mr. Brooks as he puts together his opening statement. It has reference to some Supreme Court rules, SCR, some case law, talks about the manner and purpose, scope, and other things. And as I indicated yesterday, sir, I like to call it the roadmap. It's referred to here as a framework so that the jury can better understand and evaluate evidence. It must also be based on the law and the evidence you believe is properly admissible. I'm going to further advise you at the time when you do make your opening statement that it not reference subject matter jurisdiction. That is, despite what I know you believe to be to the contrary, it is not a requirement to be proven in this case. It is not a factual or legal argument that is accurate, and therefore I'm prohibiting you from referencing that during either opening statements or closing arguments. With that, I believe
for the record, is this the which you're referring to? This
the page and a half is from my judicial bench book. I thought it would be helpful to you so that you have a better awareness and understanding of the manner and purpose of an opening statement. This is what guides me as I preside over cases.
Okay, I accept for value in return for value these documents. I don't know why the reference to subject matter jurisdiction in the opening statement. I'm pretty aware that that wouldn't be part of an opening or closing statement. I don't.
Okay, great.
I don't get why that.
Okay. I wanted to make the record clear. So I appreciate you indicating to me that you're aware of that.
Even though subject matter jurisdiction has not been proven on the record and should be addressed.
It does not need to be proven on the record. It's established by law and by the fact that, as my written decision indicates, commenced when the criminal complaint was filed in this case. It's conferred by Constitution and by statute.
And who was the complaint filed by? Because subject matter jurisdiction has yet to be proven on the record.
I'm not going to go down this path today. I'm just advising you, you cannot reference that in your opening statement.
That was something I've already had the common sense to know, but also subject matter jurisdiction has not been proven for the record.
All right, next topic then. I believe the state has filed
should be proven for the record by the prosecution.
The objection is noted. It is not legally sound. It's overruled.
It's definitely legally sound.
All right, Attorney I'm going to turn to Attorney Opper. I believe they filed a motion this morning. Has it been pulled through? I probably just need to refresh, but Madam Clerk.
It was served on Mr. Brooks last night in the jail, Your Honor.
But he don't have it.
All right, go ahead. You can make.
I didn't look at the document. I accept the accept for value, return for value the document. I didn't look at it.
Good Lord.
So I don't know what I'm supposed to say to that.
All right, well, Attorney Opper, it's your motion. I'll hear from you.
Your Honor, we are moving to amend the information with respect to one word in the entire document. We're asking to change the location of count 76. The information reads, as it reads right now, it reads at Frame Park. We're asking to change that to near Frame Park. We believe that that's a more consistent statement that aligns with the testimony of victim PPP, Erica Patterson, as she testified in this trial. We're not asking to change any criminal charges. We're not asking to change any dates. It's, I think, a very small change in the charging document. The defendant has been on notice of the facts of this transaction. It's reflected in a number of police reports and Ms. Patterson's recorded statement, which the defendant has copies of. And so I don't think that there's any grounds for a claim of prejudice by this change, and we're asking to move forward with that amendment to the information.
All right, thank you. Any position on that, sir?
Yes. First of all, for the record, there were originally 2 charges associated with this one party, and these charges have been charged for the better part of a year. I feel that if there was essentially one word that needed to be changed, it's been more than ample time for it to be changed. Even after one of the charges was dismissed, it could have been, that topic could have been visited at that time for it to change. I don't think changing one word at this point really has any bearing on the testimony or the actual charge. I don't understand why a motion needs to be heard about one word. Is I think kind of at this point kind of a moot point. It's been charged like this for a year basically. The language hasn't ever been referenced to being changed before yesterday. So what is the significance of this now at this point?
Thank you, sir. Court is guided by section 971.29 sub 2 of the Wisconsin statutes, which provides at the trial the court may allow amendment of the complaint, indictment, or information to conform to the proof where such amendment is not prejudicial to the defendant. Case law states that when an amendment to the charging document does not change the crime charged, and when the alleged offense is the same and the results from the same transaction, there is no prejudice to the defendant. State versus Wickstrom, 118 Wisconsin 2nd 339, found at page 348. It's a Court of Appeals case from 1984. And also, I point the parties to State versus Durango, 229 Wisconsin 2nd 1, and State versus Gerard, 189 Wisconsin 2nd 505. The first of those 2 cases is a Court of Appeals case from 1999, and then the second of those referenced is from the Supreme Court from 1995. I'd also point the parties to State versus Frey, 178 Wisconsin 2nd 729, a Court of Appeals case from 1993. As far as whether this is a moot issue or not, I'll find that it is ripe for determination by this court to hear this motion, and that is because the jury ultimately will be instructed similarly to what the jurors were instructed at the beginning of the case. The charges are read. Those are based off of the information, and this proposed amendment does conform to the proof. There is no prejudice to Mr. Brooks. It does not change the charge in any way. It is still the same offense. It's still from the same general information that was indicated in the criminal complaint. So for all of those reasons, I will grant the state's request to amend the information, and the state may file that document as soon as possible.
I have a question about that. So this same person is scheduled to testify again? What if something changes in the testimony?
I'm not going to answer that, sir. It would require me to speculate on what that situation might be and to give an advisory opinion, which I will not do.
But what happens if that happens?
I'm not going to answer that, sir. I can't. You're asking me to give an advisory decision. I'm not going to do that. I'm not allowed to do that, actually. Okay, so we dealt with that then.
Makes no sense.
The state has not rested yet. Will the state anticipate calling any other witnesses?
Yes, Your Honor, as indicated yesterday, we do intend to recall Detective Casey to the stand, and I'd like to make a record in that regard, please.
Go ahead.
Your Honor, Detective Casey did testify once for the state early in the presentation of the matter. His focus at that point was largely on assisting the jury in understanding the layout of the parade route, giving background and contextual information to the jury, the different parade units that were impacted, what they looked like. We showed several videos with Detective Casey just for background and context purposes. He then went on to describe his personal interaction with the SUV as it came through the intersection of White Rock and Main, and essentially that was the bulk of his testimony during his first testimony. We're seeking to recall him now. This is not unusual. It is commonly done in cases. We never excused him from his subpoena. We never asked for him to be excused from his subpoena. We always intended to recall him. We did this so that we can efficiently present the information to the jury. The types of questions we have for him now go more to the investigation itself and his role as the lead detective in this case. There will not be duplication or repetitive questions. I'm not going back to the corner of White Rock and Main with Detective Casey during this round of testimony. We want to ask him essentially about how some of the victims along the parade route were identified. We want to ask him about some of the topics that have been addressed throughout the course of the state's case, as far as identification of the vehicle and identification of the driver. And we need to still introduce the certified bail forms from Milwaukee County for the 2 bail jumping counts. So he will be asked about that. I estimate my direct examination of Detective Casey would be about 20 minutes. So this is not going to be repetitive. It's information, again, that he has as the lead detective in the case to assist the jury in understanding some of the things on the back end that he was involved in, not his role at the parade. So we have been very efficient in our presentation. I believe Your Honor would agree with that. We're not wasting time here, but we just have a few more questions to wrap this up.
All right. Any position from you, sir?
And yes, I do. And I'm going to start with what was just said, that the prosecution feels that they've been efficient in their presentation. So it seems like to me an attempt to get more questions in that could have been asked in the first place. If Your Honor recalls, Detective Casey was testifying for quite some time, to the point that we actually had to have a break before I can cross-examine Detective Casey, if you recall. He was up there quite some time. That was more than enough time for any other foundations to be laid, any questions to be asked at that time. And also, from my recollection, he was asked to be excused.
Yeah, Detective Casey did retire, and I've actually got a video on his retirement on my channel.
So, essentially having him start off and then end it I feel like it's an attempt to get questions that was maybe forgotten to be asked, answered. And essentially what more could be gained by a second testimony from Detective Casey? What more can be gained that hasn't already been learned? We learned about vehicles and identification by numerous witnesses. We've been through the inspection of the vehicle. We've been through DNA analysis of the vehicle. We've been through numerous things in regards to the vehicle. Even the reconstruction testimony. We've been through all of that. Seems like nothing more than to get extra questions answered that could have been asked from the get-go.
Seems like nothing more but a delay tactic on your part, sir.
As seeing as how he was up there for quite some time and none of those issues were raised at that time. What would be the significance at this point? When it's essentially I should be already presenting my defense at this point in trial. I don't see the relevancy of it, and to my knowledge he was excused from his subpoena. So
thank you, sir. Thank you, sir. The court has discretion under 906.11. It's a statute I've quoted with frequency during the course of these proceedings. I've listened to the state's offer of proof. I've listened to the objections made by the defendant. In my discretion, I am going to allow Detective Casey to be recalled for the reasons laid out by the state. As I understand his proposed testimony today, it is not to rehash topics that he was questioned about initially. This has to do with his investigation and role subsequent to the initial contact with Mr. Brooks at the beginning of the parade route. And as the state indicated, we'll address certain things, including identification related to the vehicle, of the driver throughout the investigation, identification of certain victims. In addition, there are 2 additional charges for which the state has not yet presented testimony, so it's proper for those as well. It's relevant, and I will allow it for those reasons. So the state will be able to recall Detective Casey, and we'll have that done, obviously, when the jury is brought out. Any other preliminary issues then from the state?
Your Honor, just I am working on going through our list of exhibits, and I will work with your clerk to make sure that everything that I'm showing was admitted and accepted by the court is what she has, so that we can clear that up before we actually arrest.
All right, thank you. Anything preliminary from you, sir?
Yeah, just a quick question about the last thing again. I will be able to re-cross-examine.
Oh, yes, you will.
Is essentially anything left off limits to my cross, or what?
I may limit, depending on where we go, if the questions deal with what he testified to previously. It's primarily to cross based on the new testimony. However, 906.11 also says this: a witness may be cross-examined on any matter relevant to any issue in the case, including credibility. It does say in the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct. So I'll give you some leeway, and I'll trust the state will make appropriate objections, and I'll rule on them if and when they're made.
Because I'm not intending to go too much back into the previous testimony, but I think it made a few points from the earlier testimony may come into play, and I just wanted to make sure.
I think that's fair.
That wouldn't be a problem.
I think that's fair, sir.
Also, really quick, I did look over some information provided by the prosecution as far as the pretrial offer that I did not have knowledge of until, I don't know if that was today, Thursday. I don't know if that was Monday or Friday or Monday, one of those days. I've put together, started to, I won't say it's completed, that wouldn't be fair to say. I've put together, or started to put together a counter offer, so I just wanted to advise the court that I was putting that together.
A handwritten counteroffer on line paper.
All right, thank you, sir. If and when you do provide that to the state, please let me know so we can make a record of that. All right, anything else? If not, then we'll have the jury brought out.
Oh, that's right. He never.
One last large map here, Your Honor. I'm going to ask.
He never did provide the
Face
counteroffer.
backwards like we did the other day.
All right, go ahead since the jury's not here. Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good morning, Judge. Lesli, Boese, and Zach Wichow appearing for the state.
State your name for the record.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments, and I would like to make a reservation of all my rights at this time.
All right, thank you. The record should reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing street clothes, specifically a suit and tie, and he is wearing a mask.
And I do not consent to being called that name for the record.
Noted. All right, so Mr. Brooks called a witness yesterday. There was an objection. I sustained it, but he also orally moved to dismiss, and I indicated I would take that up outside the presence of the jury. I didn't do that yesterday, so I just want to put on the record that I'm denying the motion without any further consideration or discussion by the parties. He listed two reasons. One was it had to do when he called the state of Wisconsin as a witness for failing to appear, and then for failing to state a claim upon which relief can be granted. There's no legal basis for those motions in law or in fact, and so that's why I'm denying them on the record today. I'm not asking for any further commentary or statements on the issue.
I object to that.
And I intend to have you call the next witness. I just want to confirm with the state who is here this morning.
I object to that ruling, Your Honor.
Noted for the record.
Present this morning, Your Honor.
I would like a legal finding of fact.
Denied.
Your Honor, consistent with the court's instruction yesterday afternoon, we have present Douglas Kohler, Detective Steve Guth, and Erica Patterson are here now and available.
All right, I expect you to call those first three before we get to any other person, not whatever order you want among the three, but those will be the three people called, and then we'll get to the next people according to the scheduling that I put in place yesterday.
I want to state for the record that I intend to appeal that judicial decision made about the motion to dismiss.
Noted for the record. All right, let's bring the jury out then.
Actually, we didn't address subject matter jurisdiction. It still has yet to be proven for the record, and I wanted to address the fact that with this, is it Kohler? Is that how you pronounce the name? Kohler?
We're going to continue with the witnesses. I've addressed subject matter jurisdiction repeatedly. There's a written decision. I stand behind it. You have three witnesses that you subpoenaed. The state made arrangements for them to be here. Whatever order you want to call them in this morning is fine, but those three are here.
That's what I was trying to address right now. I was asking about
go ahead.
the name.
What do you want to address?
The Kohler, how do you pronounce the name? Kohler? I'm still
I don't know,
having
you'll have to ask the witness.
I'm still having trouble finding the file for that particular witness.
Yeah, call the jury in.
So I don't know how I'm supposed to.
Mr. Brooks, you were well advised. These are your witnesses that the state made arrangements. You knew who was going to be called. I put that on the record yesterday. So of those three, whatever order you want, but I'm not moving past those three to jump to others.
I didn't say anything about moving past the three.
I know that. I'm just setting the tone for today that we're going to keep moving.
Okay, I simply stated I'm not ready to ask that witness questions if I can't even find
I
their
understand,
paperwork.
but that's you not having your paperwork's on you, not anybody else.
So what am I supposed to ask them?
I can't answer that, sir. You know that.
That's a rush to judgment. You can't rush me to judgment when I'm notifying the court that I cannot find the record.
Well, you did very well yesterday without your file, so
I'm saying
I
that
don't think that's the
particular
issue.
witness.
I'll make a record. Yesterday you asked a question, hold on a second. Can you have them step back out? Just they can, yesterday you said you did not have a file for one of the
Once again, the jury's like, oh, hell, here we go again.
witnesses, and you did a fine job from my perspective. So
I did what?
You did a fine job. I just want to say my assessment,
they also
you did a good
provided
job.
me with one sheet for that particular witness at that time. So I
I'm
just went
bringing
off
the
of
jury
that 3
in.
paragraphs.
How you're prepared or not is solely on you, sir. You've had all of this information. Now we're at the end of the 3rd week of trial. These are your witnesses. I presume that you are prepared in whatever way that is.
How
You're not
can I
gonna
be
hold it
prepared
up.
for? I'm not. So the witness is just supposed to get up there and just. I'm just like,
I'm
yeah.
not going to have this commentary. Okay, I'm done. The jury's coming out. Be prepared to call.
So
one of the
that's
three.
a rush to
The funny thing is that's all he did anyway.
judgment.
That is not a rush to judgment.
It is a rush
Again,
to
I'm not-
judgment.
the jury's
It's clearly
coming
a
in.
rush to judgment if I'm telling you that I don't have the
No,
file.
in
How
my
am I
opinion,
supposed?
you're attempting to delay. So
No,
let's
I'm not.
keep
I'm not
going.
attempting to delay nothing. You want to come check the boxes yourself? You always trying to pull some fast maneuvers.
Mr. Brooks,
And Miss Judge, Your Honor.
Mr. Brooks, the jury's coming in.
Yeah,
Show
and
respect to
they
the
deserve
jury.
to know this too. It's still issues that need to get addressed. We didn't even address everything.
Mr. Brooks, I addressed all of the issues.
No, I
You
still
know
had
that.
another one that didn't have nothing to do with nothing we just talked about. There was a whole nother issue that needed to be addressed that I needed to
And we'll
bring on
address
the
it
record to
later.
your attention.
We'll address it later.
It needs to get addressed now before we go any further because it's an important matter. Just like the subject matter jurisdiction is important. That hasn't been proven on the record.
Ladies and gentlemen of the jury,
Just
this
like
is
the
not
rush to
the
judgment.
time for evidence to be presented or arguments to be made by the
I
parties.
can't
The
even
jury
present
will
any evidence. You won't let me even put
disregard
any evidence in the record.
all of these statements
is a
made
rush to
by
judgment.
Mr. Brooks
That's
at this
unfair.
time. All right.
That's unfair what
The
you're
court
doing.
will address legal matters outside the
Then we
presence.
need to
Everyone
address
can
the
be
legal
seated.
matter that I was trying to get to before
And
you
you may
rush
call your
everything
next
out.
witness, sir.
I'm not calling any witness until I get an answer, Your Honor. You're a public servant.
Mr. Brooks?
You're supposed to be able to answer simple questions.
Mr. Brooks,
if I'm saying I have to bring
Call
it to
your
your
next
attention,
witness, please. That's the stage that
I have
we
to
are
bring
at.
it to your attention, Your Honor.
Mr. Brooks,
I'm merely seeking
please
to bring
stop.
an issue to your attention.
I'm telling you to please, I'm asking you to please
And
stop.
I'm asking you,
because
can
we
we
have the
address-
jury present.
I'm asking
and
you-
we need to continue with the evidentiary phase of this trial. Call your next
I'm
witness.
asking you to address a legal matter, as you said, that those have to be taken up outside of the jury.
I will
There
do
was
that
a
at the
legal
next
matter-
break.
There was a legal matter that needed to be addressed beforehand,
I
so
will
we
do
don't
it.
have to take up time,
I will do
valuable
it at the
time
next break.
afterwards to address something that needs to be addressed now. That way,
Mr.
the
Brooks,
court and you
for the
yourself are
third
on
time,
notice.
I will address it at the next break. Call your next witness, please.
Are you asking me?
I'm directing you to call your next witness.
Your Honor, we're not going to move past this, seeing as how you took an oath.
Oath.
To protect the Constitution. I have your oath. I have a copy of your oath right here. The oath that you took, Your Honor.
Mr. Brooks, I'd like to continue with testimony.
To-
We have witnesses waiting for you. Please call your next witness.
The oath that you swore to protect the Constitution, which you are now not doing.
Mr. Brooks,
So you're going
call your
against
next
your
witness,
sworn
please.
oath. You're going against your sworn oath
Mr. Brooks, call your next witness.
As you notify the jury every time when there's legal matters, we take them outside of their presence.
And we're going to take testimony right now. Call your next witness.
I merely seek to put you on notice, on the record, for something that needs to be brought to your attention and to the court's attention.
And I will address it at the
That's
next
what I'm
break.
merely seeking to do. It's something that shouldn't have to wait because it'll take up valuable time later. At least if I notify you right from the onset, you'll already know what we're looking at, and we can nip it in the bud before everything starts to roll. And
Mr.
then
Brooks,
it gets
I will
overlooked.
address it at the next break. If you want to write something down, that's fine, and give it to my clerk. I have nothing in writing. I know there's witnesses available and ready to go. Call your next witness.
Your Honor, Your Honor, you have to answer this question. You're
Mr.
making a
Brooks,
judicial determination.
Call your next witness, please.
You're rushing me to judgment, Your Honor.
There's no rush to judgment.
There is
here,
a rush to judgment. If you won't address a legal issue that I informed you that I had some legal issues that needed to be addressed before you just run right past that, Your Honor. You're a public
Mr.
servant.
Brooks,
Are you not a
it
public
is
servant?
9:37. Call
It is
your...
8:37.
Sorry, 8:37. You're right. Call your next witness.
Your Honor, you're rushing me to judgment.
There's no rush to judgment. Call your next witness,
We had
please.
a legal matter that needed to be addressed, and I'm merely trying to notify the court.
Telling you
at
I'm
the
denying the
onset-
request to address it at this. Call your next witness.
You said what?
I'm denying your request to address it at this moment. Please
How
call.
how can you deny
please
something that we're supposed to do before the
Mr.
jury
Brooks.
even comes out?
Call your witness.
I'm not seeking to be disruptive. I'm just seeking to understand why we do this
Everyone
every day.
is in the courtroom waiting for you. Please call your
Your
next
Honor,
witness.
we do this every single day. We've done it every single day.
That
So
we sure
I'm
do.
simply trying to make sure that the court is notified of
Put it
things
in
that need to
writing,
be
hand it to the
discussed.
bailiff, and if I deem it important enough to interrupt the witness, I will. But
He really in his mind he thinks that it's her fault that they do this every single day.
call your next witness.
How can I call a witness and write something down and do
You can
both?
take a minute
This
to
is the
write down what it is.
This
I'm
is
not
the
asking
reason
you
why
to.
it needed to be addressed beforehand.
Mr. Brooks,
That way
the
it
jury
doesn't
is
become an
remaining in
issue.
this courtroom. Call your next witness, please.
Your Honor, you're rushing me to judgment.
There's no rush to judgment, sir.
Are you not a public servant, Your Honor?
Mr. Brooks,
Do I not have your oath of office?
under
3 of them?
906.11, this court has the authority, as you know.
Do I not have?
Call.
Is this not a copy, or I asked for certified copies that you said on record that you would not provide for no good reason? That these are three of your
you are
oaths
doing this,
right
and I've
here.
repeatedly told you, you can see the jury's here.
You're
You're
doing-
doing this.
Listen,
we
Your Honor,
need to go
I'm
forward.
I'm not attempting to delay the proceedings. I'm not attempting to be disruptive. I'm merely trying to notify Your Honor in the court for the record beforehand. That way, everyone's at least on notice of the issues that need to be taken up, instead of waiting until a break or a lunch and things of that nature, which kills
In my
valuable
discretion,
time.
it's my authority. It's the courtroom that I'm
Your Honor.
presiding over. I'm not going to address
Is
that
this-
at this moment.
is this not your
and
oath?
I'm not going to answer
Did you not
questions.
swear as a public servant that you would protect
Ms.
the United
Brooks,
States Constitution?
call
Did you not do
your
that?
witness.
3 times. I have all of them here. Your oath, Your Honor, as a public servant. And
Mr.
now you're
Brooks,
rushing me to judgment
there's no
when
rush
I'm
to
doing
judgment.
things lawfully by trying to notify you and notify the court of issues that need to be addressed
Mr. Brooks,
beforehand.
we are in
These
the
were issues-
evidentiary phase of this trial.
Your Honor, you're
Call
rushing
your
me to
next
judgment.
witness.
You're rushing me to judgment, Your Honor. And I object
I'm
to
aware
that.
of 3 witnesses
I
who are
object-
here.
I
Call
object to
one
that.
of them, please.
Your Honor, I object to that.
Your objection's noted.
And
for the
I
record.
want a legal reconsideration of your ruling. If not, I reject that ruling and take exception to that ruling.
I understand.
I request a legal or factual basis for your ruling, a written judicial finding of fact and conclusion of law for your ruling. And if not that, an interlocutory, declaratory appeal for this matter. And if not, these needs need to be stayed until this matter is before a adjudicated court of competent jurisdiction. Because we have not proven jurisdiction in this court as of yet. Subject matter jurisdiction has not even been proven on the record, Your Honor.
No, she sent the jury back out.
I don't even know the true nature and cause of
Mr.
the
Brooks,
charges against me. I don't even understand that part
I
of it.
understand
I haven't
your
been
request.
provided a complaint. I haven't, Your Honor, there's so many issues.
Mr. Brooks,
I'm not attempting to be disrespectful in any way.
We need to continue.
To delay the proceedings.
Your requests are denied.
Your Honor, I
and I'm going to instruct the jury at this point to disregard and not consider.
Oh, my bad. I forgot they were watching.
Any of what has just happened since you walked in. It should not be held against Mr. Brooks in any way. These are legal issues that this court may or may not need to address, but they do not bear in any way on ultimately the issues that you as jurors will have to decide. And I'm instructing you to disregard what you have just heard and seen.
Your Honor, with everything that I just said, be made part of the record.
It's on the record. I'm telling the jury that it shouldn't affect anything that they're doing in any way.
Your Honor, it's a rush to judgment.
Mr. Brooks.
Because, Your Honor, I just showed your oath that you swore it took. You swore
Mr.
did
Brooks,
this, Your Honor.
Please call your next witness.
You took these oaths of offices. You did, Your Honor, 3 of them.
I understand my oath,
which is
sir,
very
well.
commendable that that you decided to be a public servant in this.
Oh, for crying out loud!
These type of matters, Your Honor. I respect it to the fullest, but also you have to uphold these oaths.
All right, I'm going to have to excuse the jury since Mr. Brooks is not calling his witness. Hopefully bring you back out shortly.
You have to honor these oaths of offices.
I'm so glad that the jury did get to see that, though.
You have to, as a public servant, Your Honor. I respect you being a public servant. And this is not to take a shot at you in any way, but these issues
Brooks,
that I have,
stop. Please
they
stop.
need to be addressed. I'm
excusing the jury. Can you please stop?
Your Honor, this is a rush to judgment. This is a clear bias.
Mr. Brooks, you are to stop talking.
Are you asking me?
I'm advising you, or you will forfeit your right to be present in this
So
courtroom for the questioning of your first witness.
Because you're holding me in contempt.
I'm not holding you in contempt.
Then how can you remove me from the courtroom when I haven't given consent?
Mr. Brooks, I'm advising you at this moment to call your next witness, or you will forfeit the right to call these witnesses.
You can't take
under 906.11. You are refusing to call a witness.
I didn't refuse anything, Your Honor. And you can't deny me my 6th Amendment right, which is
Mr.
to
Brooks,
call
do you want to
witnesses,
be present in
which
this
is to subpoena
courtroom
witnesses.
While you question your first witness? Because it is now 8:44, and you've consistently talked in front of the jury who's no longer in this courtroom on issues that you have been advised and are fully aware are not relevant to their determination, despite what you believe the law
didn't have anything
is.
to do with the
Subject
jury,
matter that is what you referenced in front of the jury, and then you referenced my oath.
The issues that I was
Subject matter
raise.
jurisdiction, as you know, is not
As I
something
don't know.
the state has to be. The state
It
must
has to
prove.
be proven. It has to be. And
You are
if it doesn't,
frankly
show me
confusing
lawful law.
civil
Show me lawful
jurisdiction
law,
in
Your Honor.
federal cases with criminal court jurisdiction in the state of Wisconsin.
You don't have criminal.
That
you
has
don't
been
even
made
have.
abundantly
You don't
clear.
have subject matter jurisdiction or personal jurisdiction.
Mr. Brooks.
Or personnel jurisdiction. You don't. You haven't proven.
You have not.
You
I
haven't proven
excuse
for
the
record.
jury. I'll give you the opportunity to raise whatever issue it was, but you need to do it now or we're moving forward.
That's what I want to do. That's what I was attempting to do.
And if you interrupt me one more time, you're going to go do it from the other courtroom. Because
so
you're
holding
being
me in contempt?
all right. He can go to the other courtroom and we will address these issues because
holding
you
me in
are
contempt?
not being respectful. You are disruptive. You are interrupting. I will give you one more opportunity. Don't interrupt me again. Don't roll your eyes at me. Don't sigh at me. You have delayed these proceedings now by 15 minutes because of your nonstop commentary. I'm going to sit down and I'm going to listen to you. What issue do you want to raise, sir?
So are you letting me make an offer of proof for my appeal?
No, because that's not what's relevant at this time, sir. If you don't need to make an offer of proof. Tell me what the issue is. You said you have a legal issue you want to raise before we get going. What is that issue?
Okay. The legal issue is this. Detective Casey yesterday testified for the second time under oath in reference to exhibits 13 and 14 that show the backyard of my mother's home
which he stated that he had been to the home, had seen the backyard, all this stuff, when in fact even speak with my mother. It was brought to my attention.
Mama called me a jail again.
My mother, in fact, never spoke to any law enforcement from Waukesha.
Would you like to add her to your witness list to call her?
Yes, I would.
All right, that's
because
fine.
she's
That's
willing,
how we'll
she's
address
willing
that.
to come.
But that's not something we needed to address this
It needs
right
to be
away,
addressed
sir.
because of the issue of the subpoena. That's the reason why it needed to be addressed. That's the reason why I was trying to attempt to
It
bring
could
it
have
to
been
your
done on a
attention.
break. All right, so
Would I be?
you're
because
putting
I have-
you're asking me to add Dawn Woods to the witness list for you.
Yes, but I also have a question about the subpoena
The subpoena for whom?
for my mother. But I would also like to subpoena the phone records so it can be made part of the record of the conversation, since the prosecution listens to all the phone calls. They should be able to have heard that phone call as well. So they should be on notice of what was said.
I don't know what phone call you're referring to. If
I'm
you're referring to a
phone
jail
call
phone
from-
call,
I'm referring
then
to a jail phone call that was made last night, October 20th, between 7:54 p.m. and 8:10 p.m., which I'm sure the prosecution has heard by now. And that also brings up the issue of perjury testimony.
sir, the way that you will address the issues that you're talking about are to call witnesses to challenge that or to present the evidence in support of your position. If you're telling me you need to add Dawn Woods to the witness list, I approve of that. You can fill out a subpoena and I'll direct the state to serve that upon her, and at the appropriate time we'll have her brought, we'll indicate when in the order of folks she can be brought in. So I'll grant that request.
Will I be
In
able
terms
to-
of the jail records, you'll have to subpoena the appropriate custodian or a witness who can testify to that.
That's what I was trying to gain knowledge of. Because
Well, I can't give you advice on that,
I'm
sir.
not trying to ask for advice. I was is that
That's
legal for
asking
me to
me
subpoena?
for, I can't direct how you do that. I can't tell you how to do that. You are acting as your own attorney and you will need to figure that out. So you have the subpoena forms. You can research the issues. You have access to legal research materials and other things. And that's how you'll have to address
I
that.
accept for value in return for value this document.
Was that a subpoena form? It is. Thank you. Is there any other witnesses you're asking to add to your, and you can also call Detective Casey if you want, just so you know.
So that make 3 times he's able to testify?
If you believe he has information that he hasn't testified to, I will give you permission to call him as well.
No, I don't think it'd be necessary. He know what he did.
In any event,
He know what he didn't do.
we're going to bring the jury
Because I know if I bring him back up on the stand, he's going to make me look stupid again.
back out, and then I expect you to call a witness.
And just so I'm clear, because I was trying to get to that issue, what witnesses are here? Because I don't have any paper for Kohler. I don't know. how to
Douglas
pronounce
Kohler, Stephen Guth, and Erica Patterson. Of those 3, I expect you to call one of those witnesses.
it. I accept for value in return for value this document.
For the record, Judge, Attorney Witchow just handed to the defendant for his benefit the police report as it relates to the statement of Douglas Kohler, since he's claiming he does not have it.
Since I know that I don't have it. So let's make that record correct.
You don't have it with you in the courtroom is what you're saying.
I can't find it anywhere.
You've had it previously.
Yes, I had it at one point.
All right. Are you ready to proceed forward, Mr. Brooks?
Yes.
All right, let's bring the jury out.
Mark says, still haven't heard a legal issue. Oh, he's so mad already, and it's early. Teresa said, I'm sure she was just trying to stop Brooks, talking about his mom and his antics, so she lied to him. Yeah, Mama lied. No doubt, Custard. How on earth has he made it to 40 years old? How on earth? Can't believe someone hadn't shot him yet. That's horrible. That's horrible for me to say, but come on now. Come on now. Y'all being slick.
Zach, can you help Jen?
Okay, thanks, Laura. I'll look for it in my email. I don't have my own witness list. Yeah, Mama gave him all of the videos in the backyard. Did Dawn call the police before or after she called Brooks on an Uber? That's a good question. I think after.
Thank you, everyone. Please be seated.
She didn't know what was going on first when she called the Uber.
Mr. Brooks, just to make sure, don't block any of the microphones with anything. Both of those microphones should be on. You want to make sure that. Thank you. All right, go ahead, call your next witness.
Yeah, the defense calls Douglas J. Kohler.
All right.
That's it. Whew. How did he not wear them out every day? You know, they probably, this was day 11, so they went in thinking, damn, it's going to be noon before we get started on bringing in the, our witnesses and doing what we need to do because of the way he is. And a lot of people say, well, yeah, but the judge let him get away with too much. She's trying to get everything on the record. I think a lot of what was done is, he just proved. It's kind of like one of those things when the police are interrogating someone, they let them do the talking and they let them talk themselves into the crime or whatever. It's kind of the same thing here. She's letting him talk himself into, I understand what's going on. I understand the proceedings. I understand how this works. And I'm competent. So my appeal's going to get thrown out because I'm competent. I did get your recipe. Thank you, Miss Patty. The Bible. Y'all hear Bruiser snoring, you guys? Yeah, I don't know why he kept blocking the microphone. I don't think he wanted to block himself from being heard, though, guys. Get that straight. Matt says I think Dawn called the police first because of how impatient she was. Stop putting me on hold. I got to help my son escape from crashing my escape. No, I think that she called. She didn't know what was going on at first. And then she started putting it together, and that's probably when she started calling 911 going, uh-oh, I got to back up. I got to do like a couple of step back to make myself look like I wasn't involved in this. Bebop says, after watching a lot of judges' courtrooms, a lot of judges are like this, actually very patient. You got to be, I guess. All right. I got a couple of clips I wanted to show you guys from my channel now that we're done with that video. So let me share this. I hope it's not redundant. I don't think it is from what we did today, but I don't think it is.
I just want to state this for the record.
He started out with a bang. Remember when they had to get really forceful with him, like the first couple of days? And I believe at this point in time, he still had his attorney. So then he comes in, and every day was a new day to him. It was like the last day didn't happen. Well, on day 6, he comes in, and I remember this specifically because I said, you know what? We got to do a video on this. Here's day 6 of what he says before they get started. You know how they normally do their morning things where before the jury comes in, they catch up on a few things. This is part of that. Oh, God, we just watched this.
I just want to state this for the record that I would like to issue the court an apology from me in regards to my actions last week during the trial. I just want the court to understand it's very emotional right now, not only for just the whole situation of the trial,
right?
The families here that have to go through,
right?
Everything that's going to be involved with the trial, but also my family as well and myself is very, very emotional. But
He's
not
such a
to
good
excuse
person.
my actions, I should carry myself with better respect than that. I wasn't raised that way.
Mm-hmm.
And I owe you, Your Honor, in the court an apology. And
Okay.
I want to stand up as a man and tell the whole court and you,
Standing
Your
up
Honor,
as a
that I
man.
apologize to the bailiffs, that I apologize for my actions.
Mm-hmm.
Like I said, that's not how I was raised. I come from a Christian background.
Okay.
My mother did not raise me that way. She did
Uh-huh.
not raise me, to act out of frustration and irritation and anger. And I just wanted everybody to know that I apologize for my actions. And I'm going to try my best to, whatever happens, to conduct myself with respect and with respect to the court.
Well, we appreciate
And I
that.
just wanted y'all to know that
Well,
prosecution, judge,
okay.
bailiffs, clerks, reporters, everybody, audience, everybody here. I
Okay.
just wanted y'all to know that.
Thank you. Thank you, Mr. Brooks.
Thank
You
you,
can
Mr.
sit down
Brooks.
now.
I do appreciate that. Understandably so. This is an emotional experience, I think, for everyone involved. I appreciate that you, upon reflection, have realized that courtesy and decorum are an important part of a court proceeding.
Well, here she kind of gives him a little bit too much credit. But I think she was trying to okay, let's start fresh, Darrell. Let's clear the slate. Because, yeah, we started off with a bang. Emotions were high. Let's settle down. We got a long way to go in this court process because, this was only day 6. And let's just start anew. A lot of kumbaya moments right here.
But I do appreciate everything that you've said. And I know we have Detective Casey, who will bring up momentarily for your cross-examination.
And that was the key word. Detective Casey, his favorite one in Waukesha. All righty. Okay. So this is the day that he's calling his witnesses. And remember, he said he wasn't going to tell them what order or anything because he didn't want them to have one up on him because he felt like he was being treated unfairly because they knew more about his witnesses than he did. It was not his fault that they knew more about his witnesses than he did. He can't help it if he can't open up the files and study at night and learn about this stuff. He prefers to do it right there while they're on the stand so that everybody can wait on him while he looks at all the paperwork and the witness statements. Anyway, he comes in on day 15 and he wants the things the way he wants things.
Don't call her right now. You will forfeit your right to call her.
Is that lawful?
I've told you what I believe my authority is. Okay,
You
if you
told
don't
me
want
what
to
you-
recognize it,
you
that's
told
fine.
me
You
your
want to object
authority.
and note it, that's
You told
fine.
me your authority.
objection
I'm
is
not.
noted
I'm not
on the
debating
record.
your authority. I'm not.
Have the jury brought back in, and you should.
Still a rush to judgment, Your Honor. You can't. I shouldn't be forced to call people in the order that I'm being told to when these are my witnesses.
You did not.
I had someone commented previously, you know who you are, and they said, "What is on the ceiling?" I thought that was so funny.
Not want to provide us with the order, and I respected that, Mr. Brooks.
But I said that
And
from the
so
beginning.
then I asked
Your
you to
Honor,
put
with
him
all
in
respect,
blocks. This is not about you. It's not about the state. It's about the witnesses.
It's about what's fair.
availability.
It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening in this court.
How? We'll already be ready.
Mr. Brooks,
That was
I
the
asked
whole
you
aim of that.
yesterday, and I would have had you
aim
come
of
in
that.
later. You didn't want to answer that question.
There was no
And
question. There was no question to answer.
That's not
I
true.
did what you asked me to do, Your Honor. You
No, you
said
didn't.
yes, you did. To
Mr.
do
Brooks,
their
here's the
to
deal.
do
The
their
jury's
cross.
coming out, and I'm going to stand my ground on this. When the jury comes back out, I'm releasing her from the subpoena.
You can't do that.
For your
Where's
lack
the
of
lawful law?
He's talking about Erica, and that's his, that's his button. You talk about Erica, you get her name involved in something, and he just starts going off. So that's when she's saying her, that's what she means.
Where's the lawful law? I have the right to
You
witnesses,
have to cooperate with this process.
but I
sir.
also have the the Sixth Amendment
Well,
right.
We have a witness available for you to call. I can require
It's
you
not
to
the
call
witness
her
that
right
should have
now.
been called at this
I'm
time
gonna
or in
play
order.
this game with you,
It's
sir.
not no game. That's
It
what
was-
you don't
it
seem
is
to
a game to
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game.
We.
I don't take this as a game. That's what nobody. That's what nobody. You don't got to explain nothing to me. Nothing about this is a joke.
I never.
That's
said
what
it
y'all
was a
don't
joke.
understand.
But there's
And it's
some things in the
unfair.
ship
It's
that's going on.
unfair and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a joke.
What type of statement is that?
Ooh.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So I think, Your Honor, with all due respect, I think you should show some respect.
We're going to take a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in
No,
recess.
you're not rushing me to judgment. I don't care what you're talking about.
Ooh. Didn't take him long to take that apology and throw it in the garbage, did it? Later in the day, and I do have cuts of this, and we will be going over this, but we're going to skip past his cross with the witnesses, and we're going to jump straight to I believe this was like at some point towards the end of the day. As you'll see, he's taken the jacket off. He's already been taken out of court one time, put in the other room, brought back in, and we'll go from there.
All right.
How are you even a judge?
All right. You may step down, ma'am. Thank you.
How are you even a judge? Come on, man. This must be all about the Q trust, right? That you want to be the beneficiary of?
I'm going to give the jury their closing instruction. We are done with testimony for today. Please
Oh,
do
the
not
jury's
begin
still
your
in the room.
And discussion of the case until all the evidence is presented. And I have instructed you on the law. Do not discuss this case among yourselves or with anyone else. It also extends to all forms of electronic communications. Do not use any electronic devices.
Watch his face, you guys. Watch him right here.
As a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them.
He's steaming.
Do not investigate this case on
Look at that.
visit the scene either in person or by any electronic means. Do not read any newspaper.
Ooh.
Please rise for the jury.
You don't call yourself a judge as much as bias you put up in here. Don't even tell the jury the truth. Got no integrity whatsoever. None. None.
Thank you, everyone. Please be seated. I would like an update on whether Mr. Brooks filled out a subpoena for Dawn Woods and provided that to the state. Has that been done?
His mother.
No, we haven't received anything, Your Honor.
Subpoena for his
and
mother to come testify.
Obviously, she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary.
Gosh, who is coughing?
Our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods.
Get them some water.
Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
He's fixing to get
So,
thug on
If
us.
I want her to be here, she gonna be here.
I agree with
So
the
just
state that
know that.
She could certainly appear.
It ain't even got to be no arrangement. All I got to say is come. She gonna come. That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you
We
to
said-
have her
we
here
said
at
all
9
that- We said
a.m.
all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a
Mr.
judge?
Brooks, I need to make a record of some
I need to
things.
make a record too.
You don't
When
need
am
to-
I gonna get the chance to do that?
All right, I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make. He hasn't sat down for the better part of 2
All
hours.
you want. You can hold me in contempt all you want.
I'm not
All
holding
you
you
gotta
in
do is tell me
contempt.
if it's criminal or civil.
So I can hit
Right.
you with you.
I need to
with
clear
what you
the
know is
courtroom because
coming.
I do need
I'm
to
gonna give
make.
you what you know is coming.
I need him to go to the
If
other
it's civil,
courtroom because I do need to put some things
if
on the
it's civil,
record. The record should
where's the
reflect
contract between you and I?
that Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
What is the
makes the
crime?
claim?
Really?
And what
He
is
is. I will make the record when we get back. I will step off, but Mr. Brooks, you're being
it ain't
taken
no,
to the
it
next
ain't no Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity.
Like
How
we
can
cool.
you even call yourself a judge? Making tacit agreements, being biased,
Tacket.
judicial misconduct, trying to steal somebody's session. It seems to me that all y'all been wanting to do is gang up. Bias, be prejudiced,
Bias.
and gang up. 4 against 1.
4 against 1. Don Woods did not appear in the court the following Monday. Brooks avoided the topic when asked about his additional witness by ranting on another topic. Yep, he said, if I want her to come, she gonna come. All I gotta do is tell her. That's one of my favorite videos that I did. Because he's such an idiot. And he did it in front of the jury. Mama did not come to court. No, she did not. She knew she would commit perjury if she did. Or she didn't want to have to not lie in front of him and seal his fate. She knew who he was. She knew what she raised. All right, I got another one. Hang on just a second. Let's pull that one up. Oh, Coffee Cake wanted to watch where Mom handed him the key. I don't think you can see it, Coffee Cake, but I'm going to share it real quick. I don't think it shows it. This is the video from the surveillance camera of her backyard. You want me to slow it down? Let's play it in regular speed. Okay, we're at 650. And then I'll play it in slow speed. But you can't see her because she comes around off camera to hand him everything. Her and that pink hair. Oh, hang on. Let me take this off. My bad. My bad. Let me put it on slow speed. She was handing him something, but she told the FBI she was handing him $4 bills so he could get some lunch. I don't think I can get it any bigger than that. Let me see what I can do here. Yeah, because I don't think I can do that. Yeah, I can't. I don't know how to do that without using my video editor. Yeah, I don't know how to show it slower or close up, but yeah. I'm fast forwarding through your comments real quick. You think it's the key? Show Poodles thinks it's the key that she was giving him. Yeah, she's an enabler. Giving her 40-year-old lunch money, Jersey girl. Yep. Mm-hmm. All right, let's watch this one.
Mr. Brooks has nothing to do with this case.
This is one of my
I have
favorite.
no idea what you're talking about. So,
I got the paperwork right here.
all right, I'm
How
going
do
to
you not
excuse
know
the
what I'm
jury
talking
right
about?
now, given this disruption.
Yeah, we can watch it, Budgie. I'll pull it up. Well, hello, everyone. Welcome back to the Scrappy Doo Brooks fan club. Or maybe it's not a fan club. Oh, wait. I don't want to say the other word, though. I'm going to fast forward through this. I was going through all my videos that I'm trying to about
Preliminary matters at this point. I've already addressed a number of things yesterday. The jury is to be brought out.
There was some things that need to be discussed about the paperwork from yesterday.
We'll take that up on a break. You can look over it. You can.
I've already looked over it, Your Honor. With all respect, I think there's.
Don't you guys hate when he starts out with that every time? Your Honor, with all due respect.
Mr. Brooks, I'm not going to deal with it right now. It's paperwork. I just wanted it notated that you left it and now it's being provided to you again.
I'm not referring to that paperwork.
I'm not dealing with the paperwork from the clerk of court's office either. I am not the custodian. We're going to bring the jury out.
Okay, but she should know that she's trying to.
Mr. Brooks,
get me to pay.
Stop. I am not addressing it.
It has to be addressed.
All right, I'm going to take a quick break and make sure the jury is ready. And
if I don't address it now.
He just keeps on talking while he's muted. It's like a child. It's like, mommy, 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 mommy. Even when the parent says no or stop or whatever, he still keeps going. Watch how he looks at the camera. Here it comes. Evil. There it is. Y'all got me on camera? Y'all watching me? Because you know, this is all part of my plea. This is all part of my master plan to file an appeal.
All right, thank you. The jury can come on out.
So you're not going to address this civil matter?
No.
And he starts back.
I was told to pay for something under a civil statute.
Mr. Brooks, I am not the custodian. Bring it up with the clerk of court.
How
I'm
can
not
I bring
addressing
it up
it.
with the clerk of court? How am I supposed to do that? So that makes me wonder if it's a
Mr. Brooks, the jury's coming out. I'm not going to address your request.
Some people will say all this is because she coddled him too much in the beginning. But all she was doing was trying to make sure he had a fair trial so that there could be no appeal.
Ask for open records. I'm not the custodian of the records, sir.
My sesty trust is being sued.
Mr. Brooks, this is an irrelevant matter that you're attempting to bring up in the presence of the jury. The record should reflect these interruptions.
Before the jury came out, Your Honor.
And I told you I wasn't going to address it. Please.
Okay, so it's a civil matter. Who's being sued? My sesty trust? Because how can I be
Mr.
sued?
Brooks, you're talking about an irrelevant matter between you and the clerk of court.
It wasn't irrelevant when I got the paperwork from the clerk of courts. I was simply
Mr.
trying
Brooks,
to address it.
I'm not going to address it. The jury will
So I'm
disregard
being
these
sued?
irrelevant
This is a civil
comments.
matter? We haven't addressed subject
All right,
matter
thank you,
jurisdiction yet at all?
everyone. Please be seated. The jury will
We're not gonna
disregard the
address subject
statements
matter.
Mr. Brooks is making about subject matter jurisdiction there.
Okay, so the civil paperwork didn't do enough. So now let's jump back to the subject matter jurisdiction.
Or misstatement of the law.
Yes. No,
All right,
it's not.
and
Just like this is a civil case.
Mr. Brooks, the jury's here. Please
Just like
show
this is a civil
respect
case.
and decorum.
According to this document, this is a
Mr.
civil
Brooks,
case,
please stop.
which means someone is being sued. Civil is a suit.
Mr. Brooks, you're talking about an irrelevant
I
matter.
have the
I'm
paperwork
starting
sent
the
by
trial.
paper course right here that says it's a civil matter.
Mr. Brooks
So
has
what's
nothing
being
to do
sued?
with
My
this
session
case.
trust is being sued.
I have no idea what you're talking about. So,
I got the paperwork right here.
all right, I'm
How
going
do
to
you not
excuse
know
the
what I'm
jury
talking
right
about?
now, given this disruption. All rise for the jury.
Civil is a suit. I'm being sued. Civil is a suit.
Addressed before the jury even comes out. That's why I'm trying to properly address it before we even went on the record.
Mr. Brooks, stop.
I'm not gonna. This is.
You are
I
not
was
being
given
respectful
this
to
paperwork
this
by you,
proceeding
Your
or
Honor,
to
with
this
all respect.
jury. No,
With
it's
all
not. With all
respect.
due respect,
With all due
stating that
respect,
doesn't make it
I was given
respectful.
this paperwork by you,
Mr.
from
Brooks,
Monica Paz.
stop talking
the
till the
clerk of
jury
court.
is out.
Okay,
Thank you.
So why couldn't we address this before they came out?
I'm
That
not
was the
going to
time-
address it.
That
Bottom
was the time
line.
to address it, though.
It has
We're
nothing to
supposed
do with
do
this
all
court.
The addressings before the jury comes out, before we start the matter.
This is part of him not understanding the whole legal process and the whole trial process, how this has nothing to do with this case. It is a separate case.
I was trying to simply address paperwork that was given to me by you, Your Honor. That states
Mr. Brooks,
it states that
you have
this is a
interrupted
civil
me
matter.
repeatedly. You are on the verge of being removed to that courtroom. I don't want to do that. I want you to stay here. But
facts of the
you
law, Your
keep
Honor?
interrupting me and bringing up irrelevant matters. I told you yesterday, as a courtesy that was provided to you, so that you would frankly not complain that you didn't get it as quickly as possible. Okay, I am not the custodian of the records. If you have an issue with what was provided to you, how it was provided to you, then take it up with the clerk of court. But from now on, I am not going to be the messenger and give you documents that you request to the custodian of the records. Or
This is right here is where she learned, okay, I got to stop doing extra things for him because he's just turning it around on me and making it worse.
from the custodian of the records. They will simply have to be delivered to you at the jail. But that is in response to your discussion or whatever we want to call it this morning. I'm not taking it up. All right. It is irrelevant.
It needed to be noted for the record.
It doesn't need to be noted, sir.
You
All right.
gave
The
it to
jury's
me-
coming
you gave
back
it to
out,
me in
and I'm
open
going
court.
to warn you, if you bring this up again, I will pause and I will remove you to the next courtroom.
So he thinks because she handed it to him in this courtroom that it applies to this court case. It doesn't matter. You know what? We will never be able to understand the mind of Daryl Brooks, and that's just the way it is.
For being disrespectful, for being interruptive, for being disruptive, and for bringing up irrelevant matters in front of this jury. You will forfeit your right to be present for the direct examination of this witness.
I object to
Did
that,
you
Your Honor.
hear what I said,
No,
sir?
I did not. I object to that, Your Honor.
Well,
I object to that. Did you hear what I said? No, I did not, but I object to that.
you can object, and your objection is noted, but if you
For the
interrupt
record-
when this jury
for
comes
the
out,
record-
they will go, I will have them taken out again, and you will be removed to the next courtroom.
You can't, what is the legal basis for that ruling, Your Honor?
Illinois versus Allen, sir, and all of the
And-
other cases that
and it
I've
doesn't
cited
say
previously.
anything-
I'll make the appropriate record. Stop interrupting me. The jury's coming out. We're continuing with this trial despite your repeated efforts to disrupt.
That's a
Yesterday,
mischaracterization
sit
of the
down.
record.
Yesterday
Sit
alone,
down.
sir, 17 interruptions, not including the opportunity that I gave you where you spent 15 minutes, okay, discussing what were primarily either irrelevant or baseless accusations and requests not based in law or fact. I was abundantly patient with you yesterday.
And you still have to
And-
verify by proof any of what I
And
said,
none
Your
of
Honor.
that is required, sir.
Because it
And
is. You can't verify.
your
any proof.
belief
Where's
that
the
that's the
subject matter?
law
Where's the subject matter
doesn't make it
jurisdiction?
so, Mr. Brooks.
That is my favorite line that she ever said. Your belief does not make it true.
Your belief that these are legitimate legal positions
They are.
doesn't change the law and doesn't make it so.
It's
So,
clearly
again,
relevant because you didn't want to.
I'm going to step off and give Mr. Brooks 5 minutes to cool off. And
I'm
when
not-
that
I don't
happens,
need
I'm
to
bringing
cool
the
off. I'm
jury
not
out,
angry at all.
and then we will
I don't need to cool off. I've done my job. I've upset you enough.
I just wanted to.
continue.
I don't.
Oh, my favorite part when he's on mute. Still going. So part of me thinks, okay, so everybody says, oh, he was doing this to delay and stall and all that. You know what? I I honestly think that he wasn't doing this stuff on purpose. This is the way he is. He is this way. And a lot of people say it's because he wasn't on his meds. But can you imagine what he was like when he was a child if he's like this now? Oh, my word. Well, I want to thank you guys for watching this little clip with me. I hope you enjoyed it. More to come.
In 8 handwritten pages, Dawn Woods made her plea as a mother to the court.
Why did you decide to write that letter?
I wanted to help Daryl. I knew that he was not mentally capable
Okay. His name is Daryl, not Darrell. His mama called him Daryl.
of presenting himself as his own attorney.
Woods agreed to speak with us provided we not show her face. She says she's received threats since her son was accused in the Waukesha Christmas parade attack.
I know a lot of people want to blame his mother for this, but this man is 40 years old. At some point, you have to take responsibility for your own actions. And I think she probably was at a point. I know. Do you guys remember when he was okay? In my defense, I just want to say something right here. This is an old video that I did. Let me see what the date of it is. This is over a year ago. My views have changed since then, but saying, I don't know if you saw in the parts of the trial where he was trying to tell the judge that at one point his mother and him had a falling out and they were just starting to repair their relationship. It was probably over him not taking his medication or going to see a psychiatrist or something to get help. So just keep that in mind if anybody's trying to blame the mom.
What has led to Daryl's behavior?
His mental illness, not being medicated.
Woods says her son should be in a mental hospital, but Brooks withdrew his insanity plea earlier this month. And just this week, a judge decided Brooks is articulate and intelligent enough to represent himself.
And he always says, you know, Mama, I'm fighting for my life. And I said, I know that, baby. But we have to look at reality for what it is. You know, I said, you did do what they said you did, even though it wasn't intentional, but you did, you know, and you're going to have to go to prison.
Daryl's not.
You know, at least she knows that what he did was wrong. At least she's admitting that he's done wrong and she's not trying to. Maybe I shouldn't play this one because my views have totally changed since I wrote this, since I did this video. But I wanted to watch the interview. So don't get mad at me, you guys, okay? This is old. To mask it. And some people will say, oh, no, she's trying to mask it by mental health or whatever. But he probably does have mental health issues. Hello? If you've been watching this, I mean, what other person would get up and do this? But at the same time, she's not trying to say, well, he had mental illness, so he should get a pass. She's not saying that. She's saying he did what he did and he should go to prison for it. So you got to give her credit for that.
Not an attorney. How do you think he's going to handle the proceedings?
Oh, mama.
I'm going to, and I hate to say this, you're going to see manic, full blown. That's what you're going to see.
Are you going to try and talk to him before the trial?
If he calls me, I will. I tried talking to him on Tuesday again.
Woods says she won't be attending her son's trial. She already knows the verdict and what her son did.
So there you go. I give her credit for that. So sad. Okay. So as far as the letter, let me open this up so you guys can see it. It says the mother of Daryl Brooks, the man accused of killing 6 and injuring dozens in the Waukesha Christmas parade tragedy, sent a letter to Judge Jennifer Duro requesting her son not be allowed to defend himself at trial. TMJ4 received a copy of the letter Wednesday, in which Brooks' mother, Dawn Woods, says she's worried about her son's mental health. Woods wrote the letter Tuesday, beginning it by saying, I'm not sure if this is right or proper, but I have to try anyway. She wrote that she is deeply concerned and has been for a month. According to the letter, Woods reached out to the Brooks attorneys a month ago expressing her concerns and saying she could tell he was becoming unstable. I think he's been unstable for a very long time. Woods claims his attorney blew her off. Yeah, that doesn't surprise me. I am now asking you to please do not let him represent himself. I tried to reason with him on Monday. When I spoke to him, he told me he doesn't feel comfortable with his attorney's way of how they want to present his case. Woods claims that she told Brooks he should voice his concerns to the judge, but he wouldn't listen to reason. He is not stable mentally enough to fully understand the big mistake he is making by wanting to represent himself. He doesn't understand. That alone should be enough to see he's not capable of being his own attorney. She went on to write that she is unsure if there is anything Duro can do, but she felt that she had to try. He needs all the help that he can get and then some. Woods proposed getting Brooks different attorneys or just a different approach. I understand the witnesses wanting closure, so do I. It's been unbearable for I think that's supposed to say it's been unbearable for us as well. Believe me when I say that he is not stable to represent himself at trial. Oh, this is the full letter. Let's see if I can read it. I'll try. I'm not sure if this is the right or proper, but I have to try anyway. My name is Dawn Woods, and I'm sure you guessed the mother of Darrell Brooks. I'm writing you because I am deeply concerned about what happened in court today. I called Attorney Perry, I think that's the name, and Attorney Keys with my concerns regarding mental state or Daryl's mental state a month ago. I told them that I believe he was becoming unstable. He's already been unstable, Mama. Come on now. I speak to Darrell on a daily basis, and by our conversations, I could tell that he was becoming unstable. Even though he always says he's okay, being his mother, I could tell. I don't know of I can't read what this says. I don't know if you're a mom, but moms always know when something isn't right. I encourage him to pray and read the scriptures, hoping that would help settle his mind, but I can see his mental health once again is taking over. When I something my concerns to his attorneys, they just blew me off and didn't take me seriously at all. I am now asking you to please, please do not let him represent himself. I tried to reason with him on Monday. When I spoke to him, he told me he didn't feel comfortable with his attorney's way of how they want to represent his case. I told him he should let you know. I guess she's writing this to the judge. And if it's possible, ask for different lawyers to represent him. He wouldn't listen to reason. He is not stable mentally enough to fully understand the big mistake he is making by wanting to represent himself. He asks questions and saying he doesn't understand that alone should be enough to see he is not capable of being his own attorney. How can a person who has a mental something fully understand? I don't know if there is anything you can do, but I have to try as his mother. If I don't, knowing what I know, I'll never be able to forgive myself. He needs all the help he can get and then some. Maybe different attorneys would help if that's possible, or maybe his attorney needs a different approach on how they plan on presenting. I guess there's supposed to be a period there. um, Presenting his case, let him have more say and input. Maybe that would help in making sure they explain and communicate letter better. I just know something needs to be done that is fair. I understand the victims wanting closure. So do I. It's been unbearable for me as well. Believe me when I say that he is not stable enough to represent himself at trial whatsoever. You can do would be greatly appreciated. He needs help. I'm asking the court to recognize his unstable mental state and rule in his best interest. Sincerely, Don Woods. P.S. I know he will not be happy that I wrote you and become angry. I hope one day he will understand I did it out of love. Bless her heart. All right. Then we have another interview. Not surprised by verdict. Remember, guys, we're going to trial here. We're starting on Tuesday, the 15th. So there's going to be a lot of victim impact statements. It's going to be heavy. So I'm kind of wanting to get some of this out there so you guys can see it before that happens.
Daryl Brooks's mother is sharing her opinions on the verdicts today. 12 News' Caroline Reinwald spoke with her, and she joins us now live. Caroline.
The hate was stopped, the hate mail was stopped, the hate emails that I'm receiving was stopped, you know, and people's hearts began to heal. My heart still goes out to the family. My condolences to all of them, but I hope that they can begin to heal.
Dawn Woods, the mother of Daryl Brooks, says she did not watch the verdict live today, but learned from loved ones of her son's conviction and says she's not surprised. When your son said that he didn't mean this wasn't
Oh, they went to her house.
intentional, did you believe him?
For some reason, I was thinking these videos were done outside the courthouse, but she didn't even go.
I know my son. I know it wasn't intentional. People who are mentally ill need help in community, family, loved ones. The court system need to give them the help that they need.
Notice she's got no trespassing signs all over her house. She's probably been bombarded. I won't victim blame at all here. If you had been one of the people that was affected by this, even if you didn't lose a loved one, but one of your loved ones was injured, the rage that you would have, can you imagine? Oh, I just feel so. I'm glad that they're going to be able to get up and speak to him, and I cannot wait to see his reaction to it all. And this is another one she did.
It sounds like you want to be an advocate. The people need to understand mental illness and understand people who are mentally ill are hurting. They're trapped. And a lot of them don't know the way I will show compassion. The families who have loved ones that are suffering from mental illness, a lot of them are ashamed to even talk about it, or to say he's crazy and don't want to have anything to do with them. But you need to, those people need help more than anything. Seek out treatment where there is. Speak up for them. Be an advocate for them. And then when you see people out in the street, you see them acting, and you just laugh at them, joking, and you turn away. Stop and say a prayer, because
She seems like such a sweet lady. And I don't know if I gotta stop this one. I should probably take this one down, y'all. No wonder I get people on subbing. I need to redo that video. Ooh, that was a year ago. Just saying. It was before I watched the entire trial. Hey, Miss Judy. Bebop said, he's not mentally ill. He's just an idiot. I cannot stand the way she says mental illness. Mental illness. I just can't stand the way she says it. Oh, don't unsubscribe yet, y'all. Please don't unsubscribe. You think he drove her to it? If she does anything as far as any vices, drinking, smoking, whatever, he drove her to it. Probably so. All right, let's watch this video of her with the FBI. I got a full video here. I want to start at the right spot, though. Hang on. Dawn Woods was being interviewed by Detective Ryder, or a special agent Ryder. He had previously spoken to Woods via telephone during a previous interview. Interview was arranged during this phone call. After being advised of the identities of the interviewing agents, Special Agent Timothy J. Walther and Special Agent David Bianchi, Woods provided the following information. Woods has been employed as a medical technician for approximately 6 years. She currently works second shift. Woods owns the above referenced residence and currently resides there with her 2 grandchildren. Now remember, this is back when this happened, okay? So she has sold the house since, is what I understand. Woods has had full custody of Anaji, who is Daryl Brooks's nephew, the son of Daryl Brooks's twin sister, who has since passed. It says that Wood's daughter passed away in 2014 from a drug overdose. Right here, guys. It's FBI. Let me show you. Federal Bureau of Investigation. So, we were all going back and forth that she had diabetes or she had cancer or something was wrong with her. Nope, it was a drug overdose. Wood's only living child is Daryl Brooks. He is currently unemployed and most recently having been living in Woods' vehicle in the backyard. Woods describes her vehicle as a red 2010 Ford Escape bearing Wisconsin registration plate ADT 9256. The vehicle currently is not insured. Imagine that. Wood stated that Brooks is not allowed to live in the residence because he is unable to get along with his family and has a history of violent behavior. Wood stated that Brooks was diagnosed as bipolar at the age of 12 following a 2-week inpatient mental health treatment. While he took medication as a minor to control the mental health, Brooks does not currently take any medication or receive mental health treatment. It says Brooks is the father of, and it blacks out the number of children. I'm not going to name his children. They just had the misfortune of him being their father. It's not their fault, so I'm not even going there. What she does say is that he had little to no contact with his oldest son and has recently been in jail as a result of unpaid child support. It's not just child support, mama. It was also she left out the part where he was abusive and got in trouble for Erica. Woods believes that Brooks was in jail on this child support issue as recently as November of 2021. It didn't take him long to get out of jail and do these things, did it, guys? Of course, we already knew this, but I guess they're saying the mother of their child currently lives in Atlanta, Georgia. Now, she does mention Erica, and she says that neither Brooks or Patterson have ever had custody of the other child. They only recently united. Okay, so remember, I'm reading from stuff that's been redacted, so I'm just going to try to make it sound so that you can understand. I'm just going to try to add some words here so that you can understand exactly what the context is. She is referring to Brooks and Eric, and I do believe, and she says they only recently reunited. Wood stated that in approximately April 2021, Brooks traveled to Georgia for approximately 2 months. When he returned to Milwaukee in approximately June of 2021, he was accompanied by Erica Patterson. Brooks and Patterson subsequently began living in a tent in Woods' backyard until approximately September of 2021, when they began alternating staying between cheap hotels and Woods' vehicle in the backyard due to dropping temperatures. Approximately 3 weeks ago, Brooks and Patterson had a significant domestic violence incident in which Brooks was arrested. At that point, Patterson moved to a shelter in Waukesha. Since his release from jail, Brooks has continued to live in Woods' 2010 Ford Escape in the backyard and runs an electric cord to feed a television and space heater. Woods stated that Brooks only has been given an electronic key fob to lock and unlock the doors of the vehicle. You're right. Woods denied providing Brooks a key to operate the vehicle, despite admitting to him having operated the vehicle in the past, to include approximately 3 days ago. So, while I was recording this, I came across something and I wanted to make a quick point. Here is the key fob that was found on Brooks. There's no fobless, there's no keyless fob. I mean, okay, so this was, and remember, guys, this was back in 2010. Okay, so the fobs were a little bit different than they are now. I mean, we're talking 13 years ago. And I remember my first key actually had to hit a button on the fob and the ignition key for the key would flip out. I think I had a VW back then. But I was trying to find on the Ford website what the key fob looked like, and I can't find anything that says that there was a fob without the key on it like this right here. So for her to say she didn't give him the key to drive the vehicle is BS, because the fob includes the key. And I did look, it does look like the Ford, you do have to insert the key. It's not like an automatic start. So just wanted to make a side note of that for you guys. On November 21st, Woods arrived home from work at approximately 7:30 a.m. She was dropped off by a coworker. At approximately 12:15 p.m., Woods exited her residence and met with Brooks at the vehicle. Woods provided Brooks some money to purchase lunch since she was not going to make anything for him to eat. This video is being shown now. This is the video from the surveillance camera of her backyard.
Oh. See ya.
Woods observed Brooks was watching the Green Bay Packer game in the car during his interaction. Woods did not observe Brooks acting any different than normal. Woods then went inside the residence and tried to sleep as she was scheduled to work again that night. At approximately 2:49 p.m., Woods, after being woken by Anaji, called Brooks. Brooks activated this telephone number in July of 2021 and currently maintains an Apple 11 iPhone. Woods inquired about the Packer game score and vented about Anaji waking her up. The call lasted 8 minutes and 21 seconds per her call history, which was voluntarily shown to and photographed by Ryder after receiving Woods' verbal consent. During this call, Woods denied knowing that Brooks had taken her vehicle without consent and again stated his behavior seemed normal. Woods believes she got out of the bed at approximately 4:30 p.m. as her ride to work was picking her up around 6. At approximately 4:53 p.m., Woods received a telephone call from an unknown number. It was Brooks on the line requesting Woods arrange for a Lyft ride home for Brooks with a pickup location of 550 Elizabeth Street in Waukesha. It was then that Woods confirmed that Brooks had taken her car without permission, but Brooks refused to provide any additional information, stating that he would tell her what happened when he got home. At approximately 4:59 p.m., Woods attempted to call Brooks again, but the call went unanswered. At 5:03 p.m., Woods received a call from an unknown number. It was again Brooks on the line requesting a Lyft ride. The call lasted approximately 1 minute and 5 seconds. Woods then called the number back at 5:05 p.m. and Brooks answered. This call lasted approximately 4 minutes and 17 seconds. Wood denies Brooks providing any information about what had happened. Woods attempted to call this number back 3 additional times at 5:10 p.m., 5:16 p.m., and 5:25 p.m., respectively. All calls went unanswered and were directed to a voicemail using the name Ryan.
Mr. Ryder, I don't know what's going on. I'm at work. I work at Trader. And my son, that was my son who you let use your phone. And he's calling. I don't know what's going on. I'm just trying to see if he got the Lyft or what, because the guy is in a white Dodge Charger. I guess apparently the Lyft driver switched cars and I didn't get the message. So I'm just trying to find out what the hell is going on. So I'm just want someone to just call me and tell me something, because I don't know.
During this time, Woods, using the Lyft application on her cellular telephone, booked a reservation for Brooks. Reservation was confirmed at approximately 5:23 p.m. with the driver assigned having telephone number blah blah blah. At approximately 5:32 p.m., Woods received notification that the reservation had been canceled and no one was present at pickup location. During this time, Woods also attempted to call Patterson twice to obtain additional information. Both calls went unanswered. Unable to get any additional information from Brooks and seeing news stories about an incident in Waukesha, Woods thought it was necessary to call the Milwaukee Police Department to file a stolen auto report about Brooks using her vehicle without her consent. Woods placed a 911 call at approximately 5:50 p.m. The call lasted approximately 3 minutes and 26 seconds and was assigned Milwaukee Police Incident Number blah blah blah.
Waukesha Police, this is Greg. How can I help you?
Yes, I was put on hold because I was calling about the incident that happened with
Yep.
the parade.
Yeah, and who was that took the vehicle?
My son, he took it. I don't know if it's my truck or not, because I saw my truck at 11:30 this morning. He's
Okay.
getting some items out of the truck, and I gave him something.
Sure. Just let me put you on hold again real quick, ma'am. Okay, don't hang up. Okay. Thanks.
Yeah, but I'm going to leave out for work, so I can't keep holding.
Okay, hang on 1 second for me though. Okay. Waukesha Police, this is Greg. How can I help you?
Yeah, I was told to hold on.
Yep. So what's your son's name, ma'am?
Daryl Brooks.
Daryl Brooks?
Right.
Darrel?
Darrell.
Okay. What's Daryl's middle initial?
E.
All right. And what's his last name? Brooks?
Yeah.
Okay. What's his birthday?
02/21/82.
Okay. What's his phone number?
I do not know if I heard.
Okay. Here, ma'am, hang on one second. Just give me 1 second, okay? All right, ma'am. Thanks for holding. What's his phone number if you know?
I will have to look it up. I don't know if I heard.
Okay. Okay. And what's your first name, ma'am?
My name is Dawn.
Dawn? The same last name, Dawn?
No. Wood.
Wood?
Wood.
Woods? Okay. I'm sorry, your phone's all broken up.
Woods with an S. WOODS.
All right. And is your phone number the 414-610-2153?
That's my number.
Okay. All right. I have an house. And you believe he was involved?
Huh?
Do you believe he was involved?
I don't know. I'm
Okay.
saying that my
Okay.
car is gone, and I just saw
Okay.
a red SUV on
Yep.
the. I don't know what. I don't know.
Okay. All right. All right, ma'am. If we have any questions, we'll give you a call. Okay. I got your information. Okay.
I did call Milwaukee Police,
Okay.
but I
All right,
can't do a
all right,
report because
yep,
I'm on my way to work.
I'm gonna put your name in the call. Okay. If they have questions, they're gonna give you a call. All right.
Okay, well, I'm at work, so I may not answer my phone. That's what I'm trying to tell y'all. I work in the
Right.
hospital.
Okay. Hang on 1 second for me. Okay. Let me try to get over an officer to be able to speak with you. Okay.
Thanks.
Okay. You're welcome. What's that?
I'm talking to my daughter to lock the door, baby.
Oh, okay. All right. Hang on 1 second for me. I have a phone number. Man, that officer give you a call. Okay. He's busy right now. Okay.
All right, thank you.
Oh, you're welcome. Bye.
All right. During the interview, Woods indicated that she had a Ring camera attached to her garage showing the backyard. Woods then voluntarily accessed her account and allowed Ryder to watch relevant captures videos activated by the motion on November 21st. After review, Woods voluntarily emailed Ryder links to 3 relevant videos. Video activities at 12:15 p.m. Woods is observed exiting her residence and approaching the red Ford Escape. Only front hood is visible. Inaudible talking is heard for a few seconds. Woods walks back to and enters her residence. So this says that it corresponds with her giving him some money for lunch. I'm gonna go give my child who's 39 years old money so he can go get lunch because all he's doing is sitting there around in the back of the car doing nothing. Video activities at 1:26 p.m. Brooks is observed walking in front of a red Ford Escape on 2 occasions. Only front hood is visible. Brooks is the only one observed on the video. At approximately 1:27 p.m., the red Ford Escape is observed backing out of the parking spot. Now, I guess this is continuing the report. It says that this is a second in person interview conducted with Woods by Ryder. After being advised of the identities of the interviewing agents, Special Agent Timothy Walther and Special Agent David Kowalski, Woods provided the following information. She stated that her son, Daryl Brooks, has a long history of mental health and behavioral issues. At the age of 12, Woods checked Brooks into a 2-week inpatient mental health treatment program at Charter Hospital, now known as Rogers Behavioral Health in West Allis, Wisconsin. Brooks was subsequently diagnosed with bipolar disorder and provided medication that was continued to be prescribed in the immediate years that followed. After his release, Brooks continued outpatient counseling through a provider identified as Renew, located on West Wisconsin Avenue. Following this inpatient treatment, Woods applied for and was granted supplemental security income for children. That's what they refer to as SSI, you guys. If you're here SSI, that is supplemental security income. On behalf of Brooks, due to his mental health treatment diagnosis, upon turning 18, Brooks applied for the adult version of SSI and was denied. I have that information and we're going to go over that because I have the applications and everything, and I even have why they denied him. Wood stated that Brooks attended Milwaukee public schools and during his childhood and was expelled from numerous schools as a result of behavioral outbursts. While a student, Brooks was subject to an independent educational plan due to his mental health and learning disabilities. The final school Brooks attended and was subsequently expelled from was Milwaukee Tech High School. During many of his school outbursts, MPS staff would transport him to the Milwaukee Mental Health Facility associated with Children's Hospital. Brooks' primary care physician, as a minor, was Dr. Sowen, but Woods is uncertain if she still practices medicine. Okay, on December the 2nd of 2021, they interviewed Anaji, Brooks's nephew. On approximately July 23rd of 2020, Anaji observed his uncle, Darrell Brooks, in possession of one of Anaji's old phones without permission. Anaji confronted Brooks over the phone, resulting in the two engaging in a repeated verbal arguments. The following day, July 24th, after continuing to argue with no resolution, Anaji and Brooks went to the rear of the yard of the residence and engaged in a physical fight. When the fight concluded with no apparent injuries to either party, Anaji attempted to depart the residence with his friend in her vehicle. While Anaji and his friend were seated in the vehicle preparing to leave, Brooks exited the residence with a pistol in his hand. Anaji observed Brooks raise the pistol and discharge the weapon towards the vehicle. Anaji and his friend immediately drove away, but returned when police arrived. Anaji stated that his grandmother, Dawn Woods, was the one who called the police after Brooks discharged the weapon. I've got those police reports too. So if y'all want to, we can go over the lengthy history of his charges, the different times he was arrested. It's amazing. He's a lifelong felon. On November 21st of 2021, this is the day of the parade, Timothy J. Walther and Special Agent David Bianchi responded to Dawn Woods' home in an attempt to make contact with her. Upon arrival, Ryder made contact with Milwaukee Police Squad, who provided assistance. Contact was then made with resident Anaji, who maintains the telephone number, blah, blah, blah. During this interaction, Anaji was in telephonic communication with Woods, who participated in the interview via speakerphone. Anaji and somebody else identified themselves. They have been under the sole custody of Woods since her daughter had died in 2014. Both observed Brooks during the morning of November 21st in the backyard of their residence. They both stated that Brooks currently lives in Woods' vehicle located in the backyard. They denied having significant contact with Brooks as he is not allowed in the house due to his tendency to engage in conflict with, both of them. During their brief interaction with Brooks on November 21st, they did not know anything about Brooks' behavior or hear anything that would be alarming or foreshadow future events. During the interview, Anaji directed Ryder to the stairway that leads to the second floor. Dawn Woods is on the speakerphone, stated that the items of clothing in the stairs contained in a suitcase and a few plastic bags were Brooks' belongings. I'm putting a photo of these up now. Woods stated that despite not being allowed in the house, she has allowed Brooks to store some of his personal belongings inside of her stairway. Woods, who maintains legal ownership and control of the residence, subsequently provided verbal consent over the telephone to conduct a search of the stairway and second floor of the residence. Anaji also provided verbal consent to conduct search of the stairway and the second floor and was present with Ryder during the said search. Consent search was initiated at approximately 8:55 p.m. At approximately 9:01, Ryder located two cellular phones with red protective cases in the suitcase located on the stairway. Phones were powered off and did not appear to have a stored charge. Anaji confirmed that the phones belonged to Brooks. 3 photos of the phones were taken by Ryder and are attached in a digital thing there, and both phones were subsequently turned over to the Milwaukee Police Department. I'm going to call that one because I've got that video up if anybody wants to watch it. I'm going to put the link in the chat right now to it, but I'll also put it in the comments once the video is up. Okay, so y'all can go back and watch that video. It's the interview from the FBI, plus some photos, plus Anaji's point of view as to what was going on, and Anaji's friend. and that was that was the Milwaukee case where he shot at them. And of course, we all know that nobody showed up in court. None of the what claimants showed up in court. The Anaji, his friend, or or mama. So we all know how that went. Just going through some of y'all's notes here. Oh yeah, Blanco. That's a good point. I don't mean to sound insensitive, but I could see her, Dawn Woods, caring for those people in the hospital right after the attack and asking them, "Did you get hit by a red SUV?" Trying to find the facts, trying to figure out what was going on. Oh yeah, Irene. He was living in a car with his wardrobe well, he was living in a tent, then they moved to the car when it got cold, and the all of his clothes were just, like, thrown on the stairs. I am a believer, though, that a lot of stuff that well, I'll say it like this. It's it's these people that keep I'm not gonna say that. I don't wanna get in trouble. Wait, what is this? The thing is, mom claimed legal advice on phone calls for all the money they're going to try and get out of this tragedy that they caused. I don't think they'll get any money. I don't see how she could get any money. If anybody finds out that she gets any kind of money from all this, I think that the citizens are going to and Waukesha are going to go after her. I would bet money that they're keeping an eye out on that kind of thing. Ugh, it's horrible. That started something I wanted to. Marianne, thank you so much for buying me coffees. I don't know if they went through or not. I'll have to go look and see on my. I usually get an email if I got them. But thank you so much. That's very kind of you. All right, so we've been on about 2 hours today. Is that Bryce Rhodes trial going on, you guys? Laura, good point. What if she didn't want him around her house or her nephew or anybody else? Why'd she keep bailing him out of jail? Why didn't she just leave him in jail? I mean, honestly, that's the part that none of us can get over. Because if she truly believed that he was a mole on society, which he was, she would have left him in jail and said, "Okay, that's where he needs to be. He needs to be there safe, keeping, keep other people safe. He belongs there." Hi, Elizabeth. Civilly, exactly, Blanco. They've got to go after her. I just really believe that they're keeping a look after that. Somebody's got an eye on her for sure. And I can guarantee if I lost a loved one in that parade, I'd have an eye on her. Just to know that she's not getting any money. And as soon as she did, that'd be it. At least one family has sued her so far, but she filed bankruptcy, right? So how does that work? I mean, oh, hey, Sylvia. Thank you so much. I appreciate you. How does that work, guys? If she files bankruptcy, does that I don't think she had anything anyway to begin with. But does that keep by filing those lawsuits, does that keep that on file that if she ever does come into money, she's got to pay all that back? Or I wonder how that works. Like how what's the statute on that? The limitation on that? You don't think bankruptcy covers court judgment? I thought it did. Okay, well that's interesting. Maybe I'm wrong about that then. I didn't And the other thing too is the whole time during the trial, she's on the phone with him. You guys, if we could just get those damn phone conversations. Ugh. I don't think we're ever going to get them though. They've released everything they're going to release. I just don't see him releasing that. Alrighty, well, don't forget, you guys, Thursday morning, he's supposed to be at at court at 8:30 a.m. We're going to be on live, and if he doesn't show up, if they don't show it on stream or whatever, then we'll watch some more clips, some more trial clips. And tomorrow we're going to do another Halderson live stream. That case is going along. And then we have the recipe exchange at 7 p.m. on Thursday. So if you want to get involved in the recipe exchange, please make sure you email me your list of ingredients, the baking instructions. Don't forget your avatar name, so I know when you're in the chat, I know who you are. And if you're never in the chat, I still want to know your YouTube handle so I can call you out on when we're doing your recipe. If you want to come up on panel when we're looking over your recipes, then please also let me know that. You have to be on the stream, guys. I can't wait on everybody to come up. It's not fair to everybody else. So if you want to be on panel, let me know. I'll call you up and you can tell us about your recipe and anything else you want to do. We'll see how that goes. I don't know if that's I don't know if we're going to have a whole lot on that stream, but I'm going to do this because y'all asked for it. If we do have a good turnout, then I'll eat my words. I'm also going to eat those recipes. Okay, I'm tired. I've been editing videos all morning. I got to edit some more videos. So I've got some crazy court clips coming up for you guys I've been working on. That's another thing. You can't be on the live, but you have recipes. If you want to send a recipe to me via email and you're not going to be on the live, I can read it for you. I would love you to send some, Irene, though, because you coming from Scotland, that'd be interesting. So if you don't mind, email them to me. My email address is in the description of the video. Hey, Rendad. You're so welcome. All right. I'm calling it. Y'all be good, and I will see y'all tomorrow. Oh, go back and check my channel, guys. I've been uploading some stuff, and people are telling me you're not getting my videos. I dropped a couple of videos over the last several days, so I haven't done just the lives. So please go check those out. Carrie, no. No what, Blanco? My email is in this description of the videos. It's also on my about section of my channel. Blanco doesn't want to go. Blanco, don't leave. Oh, if only more men would say that to me, Blanco, I'd feel better about myself. All right, y'all be good. And I'll talk to y'all tomorrow, okay? Bye, guys.